The constitutional law question from July of 2004 is an interesting First Amendment problem. This is a hypothetical that is analogous to many that we have seen in other subjects. Here, we've got three different appellants, each of them arguing the same issue. And so our job is to distinguish one from another. Take a look at the call of the question. How should the appellate court decide on the three appeals, and why? Discuss. Well, for once, we get a call of the question that does virtually nothing for us. We know that we're going to have to consider each of three appeals, so we can write the numbers 1, 2, and 3 on our scratch paper, but that doesn't really do us any good. Many times we see calls of the question that we can outline in a reasonable amount of depth. Not this time. Here we've got a comparatively short fact pattern, a cryptic call of the question, and it would not be unreasonable to get a little bit nervous apprehending a really difficult question. But as it turns out, this isn't a terribly hard question so long as you have a reasonable grip on the First Amendment. If you don't have such a grip, reviewing this fact pattern will help you get it. So take a look with me at the top of the question. We're introduced at the very beginning to a State X anti-loitering statute, which adds Section 4. And then we have a look at Section 4. It is an anti-panhandling statute. And we get the language. Then we're introduced to Alice, Bob, and Mac. I'm a little surprised they didn't call Mac Charles, but fair enough. So A, B, and M all are separately convicted in a State X court of violating Section 4. Then we're introduced to the details of each of these three criminal cases. All of these defendants are in different locations. Alice is on a public sidewalk, Bob is on a waiting platform at a subway station, and Mac is in the lobby of a private building. Then we find that these three have appealed their convictions, and it's been consolidated in the State X appellate court. We stipulate that the statute is not void for vagueness, and that the only issue is the First Amendment to the U.S. Constitution. Okay, they give us pretty much everything. What we need to bring to this question is a rigorous approach to constitutional law essay writing and a fairly detailed knowledge of the First Amendment. And both of these are not that difficult if you know it. So turn the page with me and have a look at the outline of issues that I've got for you. You'll see that the entire first section of my answer is considering the threshold issues and also going into the First Amendment. There are a couple of different ways that one might choose to organize an answer to this question. One would be to consider the threshold issues, then discuss the First Amendment in the context of the first defendant, and then with the other two defendants incorporate by reference. The other way to do it is the way I've chosen to do it, which is to play out the First Amendment issue fairly completely up front, and then examine each defendant and compare the defendant's factual situation to the law that I've already explained. Either way of outlining is fine, so long as you've got time to complete your work within the hour that you've got to do your answer. So, looking at Section 1 of my outline, you'll see I talk about standing, ripeness and mootness, and state action. These are very standard issues, and they come at the beginning of many of the answers that I've presented for your review of con law. Next, I focus for just one short section on the indigence of these parties. This is not an essential issue, but I think you'll agree that it does contribute to the analysis, and it does show that the author has a somewhat broader understanding of constitutional principles, and that's desirable. It's also desirable not to waste time on something that is not really connected to the heart of the fact pattern. I touch on it, but I don't waste a lot of time. Then I go into an upfront consideration of the First Amendment. I talk about it as a content-based statute. We're told that the statute is not void for vagueness, but I touch on it for a sentence or two, just to show that I understand where that would fit into the analysis, and I focus on overbreadth. I reach a conclusion internally about the first section. Then we move on to consider the appeals. And you'll see that the organization of each of the three appeals is very simple. I talk about each party's First Amendment arguments, and then I reach a specific conclusion with regard to each one of them. It's very simple and straightforward, and the idea of outlining is to make the answer easier to write, and maybe more importantly, easier to read by the disinterested bureaucrat who's probably getting paid by the piece, kind of like a garment worker, to review your answers. Okay, now let's review the answer that I've presented to this fact pattern. And here we'll see a little bit more, some additional instances of my doing an in-depth analysis when the issues are so narrow and so spoon-fed to us. So right up front, in the very first paragraph of my answer, I lead with the facts. I explain who Alice and Bob and Mac are. I touch on the State X anti-loitering statute, and I indicate that we're going to consider each of their appeals separately. As a group, we consider standing, ripeness, and mootness. You'll see I find a home for the law and the facts in my comparatively short paragraph. Then I move on to state action, which is really a throwaway. I cover it in 2 simple sentences. Then, for just 4 lines, I focus on the indigence of the parties. Here, I work in the idea that it is not constitutionally kosher to criminalize being poor. But this statute doesn't really do that. I move on to the First Amendment. I discuss up front quite a bit about what the law is with regard to the First Amendment. Then I indicate that this is a content-based statute, which is likely to trigger the highest level of scrutiny. Then, with regard to vagueness, all I do is I have a section on vagueness and 1 sentence indicating that the parties have stipulated that this is not a void for vagueness statute. Next, I turn to overbreadth. And here I go into a great deal of depth about this line item of the analysis. Take a careful look at this section. This ought to serve as a model to how to really amplify the analysis and clarify the legal thinking that goes into the consideration of all 3 of these appeals. My conclusion is all 3 of these defendants have standing. They all establish, their facts establish the threshold requirements for the appeals. And I also indicate that the statute is probably not going to be struck down for overbreadth. Thus, after 2 pages, finally, we turn to the analysis of each appeal. And at this point, the analysis is much more simple and straightforward. All we're doing is distinguishing each party from the other 2. Now, back in torts, we've seen questions where we've got multiple defendants, all being civilly charged with violating the same line items of the torts outline. Most typically, it's negligence. So if we've got 3 people being accused of negligence, we distinguish one from the other. Here in constitutional law, intellectually, what we're doing here is exactly the same process. So in the answer to this question, I've gone into a fair amount of depth, setting the procedural stage for the final analysis that is to come, and then going into a great deal of depth about the First Amendment issue that touches all of them. Now that we get to each appeal, we distinguish one from another. With regard to Alice, she has the strongest appeal of all of the 3 because she is begging on a public street, the most traditional public forum. I go through what happened, I apply strict scrutiny, and I conclude that Section 4 is an unconstitutional restraint of Alice's freedom of speech. Okay? Fair enough. And by the way, I think this is a situation where there really is a right and wrong answer. If you think this statute is constitutionally valid as applied to Alice, you're wrong, and it's likely to cost you points. Moving on to Bob, this is a more interesting question because we're dealing with a public area, but it's a public area dealing with rail transport. And here I go into quite a bit of depth. I think Bob's appeal is the most complicated of the 3, the most difficult to decide. Now, here I find in favor of the statute, and I think that given the higher level of care required for transportation, really of any kind, but particularly a common carrier, like a train, it seems to me that the state has got a greater interest in protecting the safety of its citizens, and there would be alternative ways for this defendant to be able to communicate his message to the public. So I indicate that State X has a compelling interest in maintaining the safety and efficiency of the public transport system. So I uphold Section 4 as it applies to Bob. This is an instance where I think reasonable people might be able to argue and reach the opposite conclusion. I think that this is an instance where the conclusion that I present probably is the better conclusion, but you could easily get away with reaching the opposite result if your analysis was clear enough. Now we turn to Mac's appeal, the last guy who was arrested for making his pitch for funds in the lobby of a private building. Here, there is no First Amendment right to free speech. And so Mac's appeal is the weakest of all of them, and you'll see that I don't spend as much time on Mac as I do on Bob. But I do go into quite a bit of depth about the issue as applied to this defendant. So now, taking a step back and looking at this question and answer as a whole, I think we can agree. This is a pretty simple question. It's a question that is not difficult to organize once we've read it, although it's certainly one that can trigger a little bit of panic right up front. So, taken as a whole, we've got a straightforward question, and we've also had a chance to carefully review the First Amendment.